Lease and Order TV. Real tenants. Real landlords. Real justice.
Performance Equity versus David Fry, 2502728.
Good morning, James Shirley for plaintiff.
Angela Jackson for Performance Equity Partners.
Your name, sir?
Fry.
Okay, so nobody appeared July 29th. I adjourned it, and then everybody was here August 27. I granted the plaintiff's motion for possession pending final judgment. Where are we with this now, counsel? Have you talked to Mr. Fry?
No, the first hearing was adjourned for lack of service, Your Honor, and reset for August 26th. Ms. Jackson and I appeared at that hearing, and this court entered a judgment of possession by default. It's a claim and delivery case involving a mobile home. Mr. Fry has now filed a motion to set aside the default, and it's his motion.
Oh, hang on. I got a slew of them over here. Okay. Why weren't you here?
Because my original court document was scribbled off where my date was and wrote above it the 28th,
Let me see.
clearly at 8th. You have the original copy. I turned it in, but I have a copy of it right here.
Your Honor,
But
you should
the
have a
date on
copy of that service.
I do. Slow down. Just slow down. Just slow down. It doesn't look very clear on my copy. Somebody changed the dates by writing on it. It still looks like the 26th to me.
I've zoomed in and looked, there's a circle on the top of it. It clearly looked like an 8 to me. And I was here on the 28th that morning and they said that it was 2 days ago.
Can you verify that he came in, Linda, on the
Yes, he did. Yes, he did.
All right. Well, counsel, under the circumstances, I'm going to set aside the default.
Your Honor, Mr. Fry has to show two things here. Good cause.
I know, but
meritorious.
but you know what? There was not enough. There's good cause. I'm looking at this. Somebody could have mistaken it for the 28th. He came in the 28th, and I'm not gonna. I don't even need to get to the issue of meritorious defense as far as I'm concerned. There's still sufficient grounds for him to have looked at this and said, I'm supposed to be there the 26th. I'm not about to penalize him for not doing that. So the default is set aside. Why you guys want to go into a breakout room and talk about this?
Your Honor, this has been an ongoing problem. Mr. Fry, as of last Thursday, is 156 days late. The last payment he made was the one this court ordered him to make back on April 7, and there's been nothing since then.
And that's because he asked you if he can make it and you said yes. And we went through a bunch of commotion at that time too.
Well, I'm going to go ahead and set aside the judgment by default, but I'm going to let him argue his motion now. Do you understand that?
Yeah.
I mean, you got to make your payments.
I absolutely will.
Well, you haven't. You got it all now? Do you have it all now?
I do. The only issue.
Hang on, slow down. Now, don't start fudging on me, please. There's no issue. You either have it or you don't have it. Slow down. Don't before you say a word. How much is owed, Mr. Sherrill?
$8,336.10.
You have that money?
Not that much.
Well, how much do you have?
I have about 4,000 I could give them.
Well, that's not enough.
Came from, I got like $2,000 in legal fees on this paper, all wrote with dates except.
Slow down. Slow down.
Only one
Slow down. Wait. What do you mean you got $2,000 in legal fees?
on this paper right here.
I don't know what paper you're talking about. I don't.
Court papers that I have. All of them are.
You know what he's talking about, Mr. Sherrill?
He could be talking about attachment 3 to the complaint, which is a loan summary.
Thank you.
That was back from June.
I gotta have that, Lisa. Linda, I gotta have that paper.
What is it?
Loan snapshot. I think it's attachment 3.
It's a breakdown of all his legal fees with Performance Equity Partners. Because we were in court the last time with you, Judge, with the same scenario. And back then he was supposed to have a judgment and paid then, and now we're waiting for him to pay
Yeah,
now.
you know, you can't come in here with half of it.
No way.
Okay, what, you're including legal fees that you're entitled to by contract, right, Mr. Sherrill?
That's correct. Legal
Well,
fees, accrued
You gotta
interest,
pay them.
unpaid escrow.
I mean, you paid in April, they tell me, is that true? April 7th, I believe? And haven't made a payment since?
Uh-uh.
Supposed to bring me current and almost all.
Well, but
These charges were before that date.
I need that document, Linda, please.
I'm working on it, Your Honor.
Okay, take your time.
I-
What? Go ahead, I'm gonna listen. Go ahead.
Okay, so I've tried to call the defendant several times after we were in court with you the last time, Judge, and he doesn't answer his calls. So I reach out to the park that he rents from, and now he's been in court with the park more than 16 times. Now we're in court with you. This is going on our third time because first it was going to be a judgment and you let him pay. Now it's like the date, so we came back and we're here now. And this is going to be an ongoing problem with him consistently. If we keep letting him get current and then we'll go back to
Don't
this.
disagree. You don't have to, let your lawyer argue this, though. Mr. Sherrill,
Yeah.
Sherrill, tell me what you want right now. What are you asking me to do? Re-enter the default?
Yes, please. With a 28-day period in which to serve it.
Do you have any?
The only thing I can do.
Correct me if I'm wrong. Did I just not, last time grant the, I really want to look at that. I just granted, my only note said I granted your motion for possession pending final judgment last time.
Okay, last time,
I'm talking August 26th.
right, that was a previous hearing in this case, correct? That's
Well,
what he's trying.
no,
Yeah,
I get, but you're saying I entered a default.
Yeah, in this case,
There's a
you did.
difference.
Yeah. Well, I had sent the court a default back on April 26th, and he immediately filed his motion. The previous case, the court ordered him to come current with it, which he did that day, and then I dismissed it with albeit with a caution that we'd probably be back, and here we are.
Okay, but as it stands now, I never entered, the default that you presented previously was set aside, correct?
I don't have a copy of it, Your Honor. That's probably what happened.
Can you verify that or not, Linda?
Your Honor, I have Gina run. She should be there any second with
Well,
your
I have
papers.
this loan snapshot, but can you verify that I previously set aside the default, or at least he presented an order, proposed order setting aside default, and that I signed it?
I'm looking right now.
I mean, it seems to me that the only appropriate thing right now, Mr. Sherrill, is for me to grant your motion for possession pending final judgment.
I agree.
Okay, so you're not
Well-
asking me to,
That looks like you signed that on August 26th.
right, because that's what I ordered when the defendant
Okay.
failed to appear. Sir,
I don't see any other judgments in here.
but there was one back in April that was entered, and I set aside or he at least filed the default, and I then set it aside on when he submitted the order, correct? I know, I'm throwing a lot at you. Life was a lot easier, Mr. Sherrill, when we used to have files.
Yeah. Would you like the previous case number?
No, I don't think I need that, do I? I mean, this is an entirely different case from the one you're referring to, right?
It is.
Okay. So you need to set aside the order granting motion for possession pending final judgment. And then indicate, and I'm going to give you a hearing right now. And you're going to tell me why I shouldn't enter the order for possession pending final judgment. You gotta pay.
I do, I just don't see how 6 payments is $8,000. That doesn't make any sense. I mean, that's what my issue with paying it was all these fees.
Well, you're in default.
They're all.
I mean, you've defaulted on these payment terms, right? Okay. So what are your legal fees? 407, how much per hour, counsel?
275,
275?
correct.
It's kind of cheap for a man of your stature.
Well, there you go.
I mean, it is. So I'm going to grant so I want you to craft another order. I hate to put you through this, but he
Yeah.
was entitled to a hearing. So you say this having come on defendant's motion to set aside default, specifically with respect to the order granting possession pending final judgment on whatever date that I entered it. And oral argument having been heard and the court having found, and if I'm going too fast, I know you're a smart guy. You can go ahead and paraphrase this. You don't have to do this word for word. Court having found there was good cause for defendant's failure to appear on August 26 of 25. The order granting possession pending final judgment is set aside and a hearing granted. And then you can go on and say, it is further ordered that following a hearing, the court has decided the court is granting plaintiff's motion for possession pending final judgment. And you can include all the other paragraphs that have to do with order granting possession final judgment.
Very good. And
Okay.
there's no request for a money judgment here. We just simply want possession.
Well, remember, you're only getting possession
Right.
pending final judgment.
Right. If this order is then served, I can simply dismiss this case once we have possession.
Well, I mean, technically, I think you need a judgment.
Yeah.
Okay, you need a judgment before you can take the property pending final judgment, but you can't, you got to have a judgment awarding it ultimately. So I would not recommend you go about it that route.
All right.
Just let me make one note here. And maybe you two can talk and compare figures. But you're clearly in arrears, whether it's 4,000 or 8,000.
100%.
Okay, hang on one second. Let me just make some notes.
I say so.
Not yet, please. There's nothing else to say. I mean, really nothing else to say. I don't know what you want to say. You're gonna have to talk to him, see if you can resolve it. You can't just let these things go like this, sir. I mean, I helped you on April 7th. I went out of my way for you and you made one payment and this is September. That's 9 months later, 5 months later, rather. Okay, I would suggest you talk to Mr. Sherrill, see if you can work something out, but do you work?
Sir,
Where do you work?
plumber. Yeah.
I don't know what else to tell you. I'm sorry. Good luck to you. Thank you. Send your order over, Mr. Sherrill, please. Thank you.
Will do. Thank you.
Philip, let me take do we have Mr. Mayer's case at 8:30? This is Concord versus Sophia Norris, 2503110.
Good morning, Your Honor. Ralph Mayers, P23815, appearing on behalf of the plaintiff. And I have good news for the court. No drama on this case, Your Honor. We're withdrawing our motion for issuance of a writ. As of Friday, I talked to the office and the defendant became current.
Okay, would you prepare an order for me that indicates, again, the defendant filed a motion to stay the issuance of the writ, and the parties have resolved the matter. It is hereby ordered that the parties agree that payment has been made and that the case be dismissed without prejudice.
Very well, Your Honor. I'll submit that order.
Is that all right? Or you want me to do something else?
No, that'll be fine, Your Honor. I'll submit that today.
Nice to see you, Mr. Mayers,
You
as
too.
always. Thank
very
you.
much. Okay. Take care.
Okay. I'm going to take, this is Sophia Norris. Philip Trefibio versus Mariah Tenant, 2502959. I just saw Mr. Trefibio out there.
He's on Zoom, Your Honor.
Yeah, I don't see him right now.
Yep, he's there.
Oh, I'm sorry. Jeez. And there's only 5 of them, not 19. Mr. Trefibio, your name?
Philip Trofibio.
Your name, ma'am?
Brian Stennis.
So I entered a judgment back on September the 2nd or thereabouts, and the writ date was September 12th. And it looks like on September 12th, you filed a motion. Do you have the money to pay this right now?
So my caseworker is working on getting my landlord registered as a vendor to accept the payment, 'cause it has to be made directly to him. And then going forward, I'm back full-time at my job, so forward won't be an issue.
I just can't, ma'am, you're not entitled to any more adjournments here. Out of courtesy, I set this for hearing. This was brought to my attention on about Thursday. And I told them to set it for hearing.
Right.
On August the 4th, you came in, said you made an application for funding. I did what I was supposed to do when I adjourned it, and then it was adjourned again from August the 18th. And then on August the 25th, I adjourned it again for another week until September 2nd. You're just not entitled to any more adjournments unless Mr. Trefibio here wants to agree to something. I can't just make my own rules up here.
The reason why the payment hasn't come through with the state yet, I had 2 parts of my application. So all these were like in the same thing. My DTE and my rent, both I applied for, they did make the payment for DTE, but they can only process 1 payment at a time.
Who'd you apply with?
SCR. Who's what?
Who, you applied with the DHS?
Yes, directly through my DHS caseworker. And I have the proof of the DTE that was finally processed.
You want to go call your caseworker right now?
I was at my caseworker's last week, and she told me that the only thing that I can take is this, which is the approval, and then.
I can't, ma'am, I just can't do anything. Mr. Trefibio, what would you like to do here?
Your Honor, I'm asking for possession.
They gotta move these along quicker. I can't just extend it forever.
I understand, I truly do, and I'm just humbly asking.
I can't make my own rules. I mean, you owe them $3,500 and that does that include even the $34.99.95? It's a lot of money. How much is the monthly rental rate on this property again?
1,100. So it's July, August. And
If you get her on, if you tell her to call in or log in, and if she tells me she's gonna get a check to Mr. Trefibio today.
she can't, she has to get him registered. She sent correspondence to him directly to have him registered as a vendor.
Hang on, slow down. Did you receive that correspondence?
Your Honor, I have no idea what that was about. I have not received any correspondence from any government agencies whatsoever.
Right, I was just down there at the end of.
Well, she might have said that. If you want to have her log in right now, she can log in.
It takes hours. I wish I could.
You just can't, I can't.
But it takes hours for them to even answer the phone. That's why I went down there in person, and called off work to go down there.
Can you,
I know, I wish I could give you something more. I truly do.
I know you do, and I feel horrible about this. But the guy has $3,500 owed. He's about to get up to 4,600 on October 1.
Well, that's not gonna happen, because I'm back at work, so I've been paid. I have 2 jobs. I work at Texas Roadhouse and Greenland Market. Like, I'm fully working again. My foot's fine. They had to process this payment first, which I have and the proof of. And now they need to register him to be able to process my rental payment.
We'll get her.
And that's the
They
correspondence
know,
they're sending.
they know,
directly.
they know how these things work.
They do, and I gave them the judgment date and everything.
So
when I
now,
went
since
back-
you applied for funding before, according to my notes, before August 4th.
I did.
So now you are up to what? 27, 49 days. And they still haven't come through with the money.
Right, for part of,
Wha-
for one part's completed,
DTE is complete.
right,
That has nothing to do with Mr. Trefibio.
right.
Ma'am, I am not unsympathetic. I just cannot ignore laws like this. I'm not gonna do that. I cannot do that. If Mr. Trefibio wishes for me to do that, I will do that. I feel horrible about it. I can tell you're upset. I don't relish in having people leave their homes. That's not a fun thing as a judge. But I can't do it. I really am sorry. I mean, I just am sorry. He's telling me he didn't receive anything from them.
I know, they just did that. So the letter that I received from them, my caseworker, and just clarifying like the first payment that went out, I didn't even get this until 9/11.
That's the DTE.
Which is the day before my rental judgment was due, so I went down there immediately. You know, kind of freaked out honestly, because it's taking so long and I'm gonna lose my house. And she said, well, you know, this is the process we have to follow. Also, we know that your landlord's not registered as a vendor.
Well, why didn't they tell you that 8 weeks ago?
I had no idea. And she said, we obviously checked to see if he could receive payment. He's not registered.
If you think you can go and get somebody on the line right now,
I mean, I
try and then come back in, Mr. Trefibio, I'm gonna ask you to stand by, but they gotta move over there. This isn't, nobody would like not receiving their paycheck. They gotta move. I mean, okay, go make a call. Mr. Trefibio, just stand by for me, will you please? Thank you.
Thank you.
Thank you.
Capital One versus Brian Phillips, 2501456.
Good morning, Your Honor. Cezanne Barta, P 65425 on behalf of the plaintiff.
All right, sir, your name?
Brian Phillips.
Did he ever sign it? It says, I signed it. I said this on August 26th. Parties reached tentative agreement. Defendant has failed to return. 3, I don't know what I can't even read my own writing. 3 documents. I don't know, or proposed conditional dismissals or judgments. Did you send it back?
I don't recall if I did or didn't, to be honest with you.
Okay.
But
have a
right
lot?
now, I'm trying to find a job. I just got.
Do you have a lot of these going?
What's that? Do I have a lot? No, I just said, this is the only thing I know about going. right now.
Did you email or send him the tentative agreement?
I got a paperwork.
Slow down.
Yes, on July 30th, we emailed the conditional dismissal to Mr. Phillips. His first payment was due September 1st and it was never made.
Like I said, I just lost my job.
Slow down.
20 minutes.
Slow down. I have to get this case resolved,
No, now I understand.
okay? So it sounds like you agreed to a conditional dismissal. You didn't send it back. And now you've already violated the terms of the conditional dismissal, which I'm sure according to the conditional dismissal allows them to go ahead and set aside the conditional dismissal and submit a proposed judgment, right? Those were your terms, right?
Correct.
So I don't know what everybody wants me to do here. I mean, you want to enter into this conditional dismissal or not?
I want to get it done, taken care of. I just, like I said, with me.
Listen, we're taking one thing at a time.
I have no problem. I'll get the payment set up. That's.
Come on, he sent it to you 3 times. And then I adjourned it 3 weeks and here we are. Actually, they adjourned it 4 weeks. What were the terms of the conditional dismissal, Mr. Barta?
It is hereby ordered and adjudged that defendant shall pay to plaintiff the sum of $5,589.26 in monthly installments as follows. $100 on or before September 1st, 2025, and $100 continuing on the first calendar day of each month thereafter until paid in full.
You couldn't pay $100?
I lost track of it. Like I said, I don't have a job right now, so I've been out looking for a job. I got paperwork here to show the fact that I've been out looking for jobs. I just lost track and this market right now is an absolute junk pile, so I'm applying for anything and everything under the sun, and not having a job is kind of hard, you know?
Well, I get it. I get it.
I mean, I have no problem at all. Let's set something up right now. Let's just, if we can just kind of let that stuff slide, and I'll set the payment.
Slow
up,
down.
Send it today.
Mr. Barton,
Yes.
do you want to try this again with a conditional dismissal of 5/5/89/26 with $100 per month beginning to be paid on November 1?
If that's what, yeah, that, I have no problem with that. I'm just trying to get a document signed. That's all.
No, so listen, no. I want you to listen to me very carefully. Is that the agreement that the two of you had, 5/5/89/26?
Yeah,
And was the agreement that you'd pay $100 per month beginning September 1? And do you agree that Mr. Barta, rather than this sending emails back and forth or sending emails that are never sent back, do you have any problem with him signing your name to a proposed conditional dismissal that calls for the same terms and conditions, with 5/5/89/26 being the balance and the first payment to be made on or before November 1 of 25, and the amount of $100 with $100 a month be paid thereafter until paid in full?
yes.
Hey, slow down. Do you agree to those terms? I'm asking you.
Me? Yeah, I agree with them. I'll go down to.
Slow down, slow down. Does he have your permission to sign your name to this proposed consent judgment?
Correct.
Okay. Does that satisfy you, Mr. Berta?
Yes.
So he'll submit that document order, but you gotta stay on those. You got,
November 1st.
where have you applied at? This job's still all over, I think. I don't know. Maybe I'm wrong.
It's crazy. Like I said, I'm going down to the Michigan, job fair. and
Good.
Did the paperwork. I got an interview with Norfolk Southern, so I mean, like I said, I've got.
Something will turn up. Just keep looking.
Yeah, exactly. It's.
I know it's harder now, but
It will happen.
how old are you?
That's what's that?
How old are you?
56.
When did you last work?
September 29th.
Last year?
No, this year.
September 29th is in a week.
Oh, yeah, I got, laid off on September 29th.
Of 24.
Yeah. So I'm not 24, I'm sorry. It's been about a month and a half I've been off work.
A month and a half.
Yeah. I've been applying,
Where were you working?
where was I working?
Yeah.
I was working at a GM Factory, Zero, for Airmark.
Were you entitled to unemployment benefits?
I'm getting 446 a month, or a week.
Well, you're better off making 520 a week if you're working than 446 if you're working, but I know some of us don't look at it that way. Good luck to you. That's the best I can do. You gotta find a job. I really wish you well. Good luck.
Yeah, thank you very much for, taking care of this for me.
Thanks,
Like I said, that will be done.
Thanks, Mr. Barty. Do you have another one, sir?
No, have a great day.
Hey, you too. Thanks a lot. Thanks. CKS Prime Investments versus Affy Cobbs. 2502297. Mr. Cobbs, your name?
Hey, Guy Cobbs.
Where is the Mandrich Law Group?
I don't think I have them checked in, Your Honor.
Karen Lowy, you have to take your hat off. I know it's a Notre Dame hat, it looks like. I'm just kidding. But you still have to take. Okay. All right. They're not out there?
No, I brought everybody in right now, and because some
Where
people I
is,
weren't.
Where is did you, I looked at my notes. It says you guys reached a tentative agreement. Did you send it back, Mr. Cobbs?
Yes.
When did you send it back?
The same day we had the last court meeting 2 weeks ago, I believe.
Linda, do I have that in my inbox by chance? I didn't sign orders on Friday. Can you double check?
I can check. I'll let you know.
Okay, I'm just gonna pass this for now. Do I have Constance Melvitz versus Chuck Davidson and Chuck Davidson Concrete LLC, 2502422?
You do for the plaintiff side, Judge.
Yes, Your Honor, for defendants.
All right, you want to go ahead and deal with the motion, counsel? Mr. Chesney?
That's fine, Your Honor. Chris
Can
Chesney.
I ask you a question?
Yes, Your Honor.
It looks like all he did was represent Mr. Davidson in a civil infraction. Is that true or false?
A couple civil infractions, yes, Your Honor, and they were trying to hire him for a personal matter as well.
But they did.
My understanding is no, it never proceeded.
So I'm correct. I just want to be correct. I just want to know that I'm correct on this.
Yes, Your Honor.
You're moving to disqualify Mr. Camilleri because he represented Mr. Davidson on 2 civil infraction cases. Never represented the business though, correct? The business per se?
And that's part of the MSD, Your Honor, because the LLC is.
No, I don't want to
different
talk
than-
about
yeah.
the MSD.
No,
He says there's a different name on the permit. Whether I grant this or not, I'm going to deny your motion for summary. Discovery doesn't even begun yet. He can amend the name of the party if he needs to. So let's not even talk about your motion for SD. You're telling me that Mr. Camilleri should be disqualified on a breach of contract case between the plaintiff and your client. And there are 2 named, Chuck Davidson and Chuck Davidson Concrete LLC, because he represented Chuck Davidson on 2 prior civil infractions. That's your argument. I just want to make sure I'm understanding it and summarizing it correctly.
Yes, Your Honor, in a general summary, yes.
Well, I don't want to hear general. Let's get specific then. You get specific with me and tell me why he needs to leave. I don't see your point after I read his brief.
Understood, Your Honor. So if you look at our particular motion, you'll note that there were some communications between Chuck Davidson, his son, and Mr. Camilleri for the civil infractions. Yes, but the civil infractions were for Chuck Davidson and the DBA business, Chuck Davidson.
They were for speeding though, right?
I think one was also like a weight thing for the trucking business, which was part of the whole
Overweight
DBA
charge?
situation. I'm sorry?
An overweight charge?
Yes, I believe one was an
Is that true, Mr. Camilleri?
I would suppose so. I know it was a commercial vehicles, but Judge, you know how those work.
I know. This is a breach of contract case, right?
Right.
Your client was hired to perform some cement work, right, for the plaintiff?
Yes.
And the claim here is that the plaintiff, that the defendant did not adequately perform the cement work, right?
Yes.
So you got to convince me. I'm not even close right now.
Understood, Your Honor. I would just advise the court essentially that when this suit came in, my clients were surprised because they had open communication with Mr. Camilleri, that they've reached out to him previously to handle issues such as the citations. So when the suit came in, my client
Might have been surprised. We're always surprised. There's a lot of things to surprise us as we go through this crazy life. But the question is whether he's committing an ethical violation by representing the plaintiff. And I got to tell you, I don't see it.
Judge, I know no more about their business operations than I know about artificially inseminating a giraffe. Okay.
All right. Do you have any basis to believe, well, I don't know if I needed that comment, but but this is the rule. A lawyer who has formally represented a client in a matter shall not thereafter represent another person in the same or a substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client consents. This has nothing to do with him learning some business operation by virtue of a attorney-client relationship that might allow him to have an advantage on behalf of this client because he knows the manner in which they conduct their work, and that will make it easier for him to prove that the work was not performed in a workmanlike manner or or that they breached the contract. That's the way I see it. I'll give you any other opportunity to respond you want, and then I'm going to rule.
Thank you, Your Honor. I would just like to note, I think you were referencing professional rule 1.9 about former clients, correct?
Correct.
Right. And I believe our motion, we were identifying 1.7, which was existing ongoing clients. And that is.
How is that an existing ongoing client if the case isn't pending, is it, Mr. Camilleri? You resolved it. It was 2 years ago. It was a traffic ticket, right?
And probably in 15 minutes, I probably resolved it.
Go ahead, Mr. Chesney.
Understood, Your Honor. And that's kind of where, and we've already discussed this about the surprise to my clients, because they've reached out to Mr. Camilleri. They basically had him, what they thought was somebody to reach out on an ongoing basis, which the documents that I attached were attempting to show that. And for instance,
They reach out to him on this case?
not on this case, because the lawsuit was filed and they received it, and they see John Camilleri on the other side. So obviously they can't reach out to him. In our clients,
Notified them in writing that he was going to sue, but go ahead. I don't know.
My office reached out to Mr. Camilleri saying, hey, my clients are, and the emails were in the motion, Your Honor, about, hey, weren't you representing them? And Mr. Camilleri argued, well, he didn't much argue. He just said, I don't know why I would be disqualified. And we identified the fact that on the same day that Miss Malvitz's the work was performed for Miss Malvitz, he was actually in the hearing on behalf of Davidson Concrete, Chuck Davidson, for the citations, the same July 3rd date, Your Honor. So we have this ongoing situation where I understand the July 3rd, 2023, where are these particular dates. So we have this, what my clients felt was an ongoing relationship. There's no end of relationship.
That's not the standard. I don't know if it's a standard. That's not the standard. He has to learn something from his prior representation. If he represented the corporation 3 years ago on a very similar matter, that might be a different story, or 2 years ago. But he didn't. He represented them on a traffic ticket. And it might not be good practice for a lawyer to do this because he upsets people, obviously, as he has your client, but I see no basis whatsoever to disqualify him. The motion to disqualify Attorney John Camilleri from representing the plaintiff is denied. I want to order from you, Mr. Camilleri. I've read your briefs. The motion for summary disposition is dismissed without prejudice. He has the right to conduct discovery and determine who the proper party is. He's given me an argument that a permit was issued to the defendant in his brief. And I think I'm going to just go ahead and deny that right now. I am going to go ahead and deny that right now. I am going to go ahead and now conduct the pretrial, and then you guys can come back at a later time. Nobody demanded a trial by jury, correct?
We have.
I think a jury demand was filed, wasn't it?
By who?
Hang on, Judge.
Judge, if there was one filed, I believe you would have it in your packet.
Okay, I just usually see it on the register here. Let me just double check that before I.
Oh, yeah, Judge. I filed a jury demand. I have it in my file.
Folks, hang on a second. Can you please we got signs all over the building. Can you please shut your phones off? Please? I'm sorry. Did somebody demand a jury trial or not? I don't see one.
Your Honor, I have one that was filed from Mr. Camilleri's office on June 13th. It was stamped in 33rd District Court.
It's true, Judge. It's stamped at 7:46 a.m. on June 13th.
That's fine. That's fine.
I would request, Your Honor, defense would request an opportunity to actually file a formal answer then as well, since this was a motion in lieu.
All right. What's your P number, Mr. Chesney?
80969, Your Honor.
And I'm sorry, Mr. Camilleri, yours again?
47348.
All right. So we have a jury trial. That's great. How much is this claim for?
$18,000, Judge.
All right. So we're going to have a settlement conference date. I'm going to put down 1 day for trial. I'm going to give you guys, how much time do you guys need for discovery?
I would think 60 days, Judge.
All right. So today is September 22. I'm going to give you until December 1 to conduct discovery. You have to file your witness list by November 1. I am going to have you guys file a trial brief, and it has to be filed and exchanged not later than 7 days before the trial date.
Your Honor, my only concern on the discovery is defendant hasn't answered the complaint yet. So he's got 21 days, I guess, to do that, and I'd hate to have the discovery shortened.
Make it December 15th, and witness list due November 15th. I'm going to say, can you file your answer to complaint earlier, counsel?
If you can give us 2 weeks, Your Honor, yes.
Defendants to answer complaint and file affirmative defenses by, I'll just say October the 10th. Okay, and that should give everybody enough time. Now let's set up the jury trial date. No motions, by the way, are heard on the date of trial. All motions in limine and all other motions have to be filed and heard not later than 20 days before the trial date. Why don't you give me one, and I'm not going to adjourn this, guys, so you got to make sure that everybody's available. So you guys can pick a date in the latter part of January, early February, and I'll be in, but just understand, I'm not going to adjourn that. I'll need a Friday from you, and I'm going to have a settlement conference 2 weeks before the trial date, Lisa, or Linda, before you send out the jury notices. So we'll want to have a settlement conference with all parties involved. Your clients are going to have to be here too, Mr. Chesney. I want to do this in person.
At the settlement conference, Your Honor.
Correct.
Yes.
Can we do it on the 23rd of January, the jury trial, and then have the settlement conference? Oh, that would be, let's see. Sorry, Your Honor, I don't have a 26 calendar yet, so I'm using my phone.
You got January 23rd of January 26th.
Yeah, the 23rd for the jury trial.
Are you
That's
both
a Friday.
available then?
No, Your Honor, I'm in Monroe County Circuit Court for a trial.
Okay, how about the 30th?
Yes, Your Honor.
January 23rd. Are you good on that day, Mr. Camilleri?
I'm good.
January 30 at 8:30 will be the jury trial date. Again, witness lists are due November 15th. Discovery cutoff December 15th. You know what? I'm sorry. Yeah, that should be a good enough. That should be long enough. And then we'll set the settlement conference date. And all parties have to be present in court in person. And we'll set that for like 2 weeks before that. Linda.
How about January 12th at 8:30?
What day of the week is that?
That's a Monday.
Okay, so I just wanted to double check. Martin Luther King Day is the following Monday, so we'll do January the 12th. January the 12th will be the settlement conference date, and that will be at 8:30 in the morning. And everybody has to be here, okay? Now,
in person.
I don't care if you file requested voir dire questions, but I want to be clear. Counsel shall submit proposed jury instructions and proposed verdict form not later than 10 days prior to the trial date. So you got, I don't care about the voir dire questions, but yeah, you got to submit your proposed jury verdict form and your jury instructions on or before 10 days before, which would be on January the 20th, okay? All right. Do I have anything else I need to address, ladies and gentlemen?
No, Judge, you're gonna issue an order for discovery though, commencing.
Yeah, we're gonna prepare this, and it might take us a couple days, but we will send this out. You should have this no later than Thursday or Friday.
Thank you.
Okay, anything else, Mr. Chesney?
No, Your Honor. Thank you.
Thank you very much, ladies and gentlemen.
Thank you.
Good luck, man. Thank you. Thanks. Mr. Trefibio, are you gonna be around your house?
Yes, Your Honor.
Do we have your phone number?
No, but I can provide it.
Lisa or Linda, I want you to give me it, Mr. Trefibio.
Area code 313.
Where are you now?
I'm in Brownstown.
What picture is that behind you? I'm just curious. Is that a golf course?
That's the 16th hole at Oakland Hills.
Oh, okay. Nice picture. I mean, it's a little obscured by the light, but at any rate,
well, it's
defendant's
signed by the artist.
defendant's motion is denied. Writ to issue. If she comes back, we will recall you, but I can't in good conscience let this go on anymore. So I'm going to deny her motion, writ to issue, and I will sign the writ today. Okay?
Your
Thank you
Honor,
very much.
Do I need to come down to the courthouse and sign anything, or?
Did he already submitted the application for a writ, right?
Yes, I just have to scan it to you.
Yeah, so I'll get it sent over to me and I'll sign it. If you've already signed it, you're good. It sounds like you did. Okay?
Yes, sir.
If she comes back, we will call you.
Okey doke.
Thank you.
Thank you, sir.
Everybody stay seated. I'll be back in a couple minutes. Thank you.
Hi, Mariah Scott.
Sir, your name?
Philip Trofibio.
You haven't heard anything.
No, I was on hold with them, so
I just can't do anything.
I know.
I'm sorry. I'm gonna have to deny your motion, writ to issue. I really am sorry. I sincerely, I just can't make up my own rules here, and I'm sorry. I really am. So I'm gonna have to sign his writ. I wish you well, ma'am.
Thank you.
I really do. Good luck to you.